Hey guys, I got a treat for you today. We're here at OV Law. We're going to meet with Brent Smith, and we're going to take on a subject that's often not thought about, but very important and can catch you off guard. It's estate sales. So that's death in the family and when somebody becomes an executor. So extremely important conversation. Brent Smith is definitely going to be the one to shed some light. Let's come on in and meet him. Okay, we're here with Brent Smith. Brent, thanks again for taking the time to take on this subject here today. I thought about this a little bit. I think the easiest way to shoot this video would be, let's walk this through as if either yourself or me get a call from a client or an individual. They just experienced a death in the family, unfortunately, and they just have no idea where to start. Brent, can you just shed some light on this one for us?
Thanks, Ryan. If there is a death, the first thing to do is to contact the funeral home, get in touch with the director, and what they're going to do is put a stop on any payment that the deceased would be receiving, any government subsidies or any other benefits, to ensure there's no further funds coming into the deceased's account. From that point, you're going to have to locate the will. Often, the deceased would have a package somewhere in their possession, in their home, and that would indicate where the will is stored and kept for safekeeping. Most often, that would be with the law office, and from that point, you're contacting that office and arranging an appointment with the lawyer to determine what is required and if probate is required for this estate.
We have the executors who have met with Brent. They have the will. We've reviewed everything. We have a tentative timeline with when probate would be complete. Well, we know that it needs probate. We have a tentative timeline of when probate's going to be complete. I think at this point, the family's going to be wondering, okay, like what do we need to be doing here in order to prepare the biggest asset normally in that estate, being the real estate, for market or for sale. So that is where, it's a call to a realtor. I know on our team, we're very fortunate to handle a lot of these, and we do go above and beyond. So initially, where we like to start is sitting down with the family and determining, it's the contents, right? So it's always the four major things. It's, okay, what is the family keeping? What is the family giving away? What are we disposing of? And what is the family selling? So those are the big four. Like you need to look at the contents of this house and determine right then and there, okay, this is what needs to be done. So quite often we could recommend Preston call maybe an auctioneer. Sometimes family goes to auction, or they work with myself and my team to sell, dispose of the items. So once that's all done, the contents are kind of taken care of. Normally what we're going to do is we're going to want basically a vacant home. Or we work with the stager to determine pieces that we'll use for the staging. So pretty much a vacant home, though, is what we'd like to see. And then at that point, our team's going to come in. We're going to completely stage it. We don't want it feeling like an estate sale. Quite often, that's kind of what happens. Is in the past, people have kind of listed these and they just put them up with, people's personal belongings all over the place. They almost got their old cup of coffee on the table, and it's just not a very good feeling. Like we really want to dial this property in for its best, best return on investment. So that's where our team kind of comes in, takes over. We help you clear it all out. We stage this property, professional photos, videos, and now we're ready for the market.
So in meeting with the executor, in determining the value of the estate, if there is real estate, for example, we're going to be advising the executor to communicate or contact with a real estate agent to give fair market value of the real estate, or either an appraiser, which are typically able to as well. But what we're trying to do is just get a most accurate value of this property to include in the probate application. Then once we have that, and we've also identified all the different bank accounts, mostly it would be the non-registered accounts, the checkings and savings, any GICs, for example, they would all be included in the value of the estate, and same with their personal effects and household contents, which can often be determined by, for example, an auctioneer, or if there isn't much there, it's more or less just going through the individual items and finding the ones that are worth the most and identifying those in the probate application. And then it's submitted. And when it is submitted to the court, we need to pay what's called estate administration tax, previously called a probate fee, which is approximately 1.5% of the value of the estate, which is submitted at the time of filing.
And going back, that is normally where I receive that first call. You know, whenever you guys are looking for, okay, approximately what the real estate's worth, that's normally whenever I get the first call as the realtor, and we simply go into the property. We issue you a piece of paper. It's called a letter of opinion, and we normally email that directly to the lawyer's office.
And if in the event we use the letter of opinion and it sells for considerably less than what the value is in the letter of opinion, there is an option to adjust for, after receiving the probate application, to receive some of the estate administration tax back to the estate.
Okay, I didn't know that, so that's good to know as well. Yeah.
Another thing that we would be doing with the executor of the estate is reviewing their obligations or responsibilities to the estate. So in terms of the real estate, they would be the ones responsible for maintaining insurance, for example, and potentially checking in on the property.
Yeah, and that's just another big one flag that kind of comes up whenever I'm dealing with estate sales. The one thing I just want to caution is really quickly, with normally these homes are vacant, being the estate sale, and you got to watch the insurance premiums. Like, they will jump up on you because it's a vacant home. You touched on it as well, the checking in on the property. Again, that's where we can help you as realtors. I have a client care manager, and we don't mind popping in on properties and just checking on them periodically as a request from the insurance company. So yeah, probate. That's the word there. That's the word for me. That honestly, whenever I first got into real estate, I don't even know what probate is. You know, so that one was was learned as the big one, right? So probate being, in my head, it's like, okay, we always just needed probate in order to close the deal, and we would run into issues too where we would see it in real estate where a house would sell and probate wasn't even completed or it wasn't done, and that was at fault of A, the executors, and B, the realtors involved just not having that knowledge. So I think there's just a lot of there's a lot of muddy waters whenever it comes to that kind of stuff. So let's take on probate. Can you explain probate for us and just walk through again how important that is and when we can list and not list?
When the client would come in to meet with me, they would bring the death certificate. The client would often be the executor of the estate. They would have already been identified in the will, and they'd have to prove their identification in order to be able to communicate with them. We're then going through, from that point, the estate assets and debts, and we're going to determine whether or not probate is required. It's not mandatory for an estate or for an executor. What it does is it designates with a certificate that this is the true executor of the estate. So they're able to communicate on behalf of the estate, which is otherwise just an inanimate object. It's just a thing at that point.
Yeah.
So the executor would be considering the assets. They would go through, and if there's real estate, most often that real estate will require probate in order to be able to transfer that property to a beneficiary or to a purchaser. Not always, so it's good to speak with your lawyer to determine if there are any exceptions to it. But most often, if there is real estate, and eventually if there's real estate, it will always require probate.
Yeah. And that timeline, the big one always becomes kind of timeline, right? So the family or the executors are always kind of wondering and considering, okay, well, when can we actually sell this? Typically, what have you seen? Like, I know in COVID, it was, over a year, but what are we seeing now as far as a timeline for probate to be completed and the family could sell that property?
Yeah, so once the executors identified all of the different assets and all the different liabilities and expenses, we're able to put them all together in a probate application, which is actually called a certificate of appointment of the estate trustee, either with a will or without a will. It's submitted to a court for review and for the issuance of a certificate, the probate certificate.
Yeah.
With that, you're now able to go ahead and sell property. Although I've seen quite a few instances where an executor of the estate is preemptively listing a property. So in that situation, the realtor working with the vendor would be looking for a closing date that would give enough time to get probate. And there's some risk on the purchaser in accepting that without a certificate of appointment, a probate certificate.
Yeah.
Because if it's not provided at the time of closing, then there's no way to transfer the property to the actual purchaser.
The other individual. Yeah. So approximately timeline now, what are we seeing? Like 6 to 8 months type thing? Would that seem accurate?
Court dependent.
Yeah.
Locally, Pembroke Court has a rather quick turnover in probate applications.
Yeah.
We're seeing often within 2-3 weeks, even quicker sometimes. If you're going outside of this jurisdiction to either say Perth or Ottawa or elsewhere, it could be longer, often is. And I've even had an application where the court had advised that by listing the property, they can speed up the probate application. I've even seen another situation where a court has advised that with an executed agreement of purchase and sale, they're able to speed up the probate application.
Again, on the subject of probate being the big build balloon here. I don't get asked the question, but sometimes it does come up. What's the deal with probate? How can we avoid this if needed? Can you shed some light on that, Brent?
It's a frequent question that I receive. It's, should we add our child onto title as a joint tenant to avoid property? Of course, joint tenancy has a right of survivorship. So if a joint tenant passes away, it doesn't go to the estate. It actually stays with the surviving joint tenant. In terms of adding a child onto title, there are situations where it may make sense, but you have to proceed with caution. In terms of adding them, if they are on title and they have any creditors with any judgments, those executions can be registered against the property.
Okay.
And the child would also be able to avoid any sale. So if you just wanted to list your property, you're in the right position to kind of transition to something smaller, you need the consent of whomever you just added onto title.
Gotcha. Okay. Yeah, that's some interesting stuff. Some stuff I didn't know. So, okay. So another hot topic here when it comes to probate and estate sales. It's something that I've definitely dealt with as a realtor. Is what happens whenever executors disagree. Like there could be more than one executor, right? And and I've seen it, we've seen, large families, maybe there's 2 executors, but there's 7 siblings. It's a very hard, situation just because everybody has their own opinions, right? And they're all basically beneficiaries of the estate, right? So, can you shed some light on that? Just like what happens if people can't agree within the estate?
Yeah. Of course. Yeah. So it's something I would caution anyone who's drafting a will. If they're looking to add 2 people as co-executors of an estate, they're jointly appointed. So all decisions will have to be made joint, but they also need to be made strictly in accordance with the instructions in the will. So if there is real estate, for example, and it's not specifically left to a beneficiary, then it's going to be the executor's almost obligation to list and sell that property or have it appraised by either a realtor or an appraiser and come to terms of agreement with the, say, beneficiary wants to buy it from the estate. Well, it's going to have to be fair market value unless they agree otherwise. But ultimately, the executors are responsible for acting for the estate, but also they have to act for the benefit of the beneficiary. So the executors can go ahead and sell the property. The beneficiaries would have a right to purchase the property, and that would often be done at fair market value.
Yeah. Okay. So we've all seen the scenario though, where every family has them, a bad sibling, someone that doesn't disagree. Does everybody in that estate have to agree on everything? Like, is that what you're saying? Like even if there was one sibling who's not an executor, do they still have a say in all this? And it has to agree to that?
Ultimately, no. It's the executors who have the obligation to wind up the estate.
Yeah.
And who they're actually following the instructions of is the deceased. So in the will, presuming there is a will,
Yeah.
they need to strictly adhere to those directions that are mentioned in the will. Okay. So if it mentions that this property will be transferred to this beneficiary, that's what they're obligated to do. If it's silent to that, then ultimately it's their decision. It's the executor's decision.
Yeah.
They can go ahead and sell it to a beneficiary, although they would need to keep in mind all the other beneficiaries, and I would be cautioning them to get their consent prior to doing so.
Okay, good to know. So I can avoid the phone calls from the brother or sister who doesn't disagree with everything.
You can, though.
Yeah, that's great. No, we'll take everybody's thoughts into consideration, and quite often that's what we have happen whenever we're marketing the properties. Again, everybody has their input, but myself and my team, that's totally understandable. It's a big asset, and we want to make the whole entire family happy if possible.
Of course.
Yeah. Okay, so here's one that's happened before as well. I know you've experienced it as well. Very unfortunate. What do we do if there's no will? Like, what's going on here now?
It's a tough predicament. Ultimately, with no will, no one is appointed to be able to wind up the estate. So typically a next of kin, if that's not available, a close family friend or whomever, would have to step up and apply to the court for what's called a certificate of appointment of estate trustee without a will. And ultimately, we were trying to get any beneficiaries information who would be entitled through the legislation as opposed to entitlement through the will. With that information, then the person who is stepped up, so again, typically next of kin, would be applying to the court and obtaining the certificate that way.
Gotcha. And they would do that through a lawyer. Obviously, you'd be helping them through all that.
That's correct. That's usually where we would come in and that sort of will gather all the information, any required consents, and apply to the court.
And I would assume that would come with like extended timelines and stuff like that's going to take.
Often, usually there's a motion required as well for this, and also potentially a bond required.
Gotcha. Okay.
Yeah, just to recap, if there's been a death in the family, first and foremost, you should be communicating with the funeral home. Locally, we have some very good services, and what they're going to do is effectively give you some death certificates and also cease payment on any government benefits or any subsidies that the deceased would be receiving. And then with those death certificates, you can go locate the will, contact the lawyer, assuming there is one, go through the instructions in the will, locate all of the assets, determine a value for any, and you can start the process in probate and winding up the estate.
Gotcha. Okay. So yeah, that's a great little recap of the timeline of this process. Hopefully you find this video helpful. Maybe it'll be one that you'll think of down the road whenever this sort of situation happens with you. But if you have any other questions or comments, certainly reach out to any one of us. Our contact information is below, and we'd both be happy to help you through this process. It's a very touchy point in time, but it's a very emotional process, but we're definitely both here to help you out. So again, one of the things here with probate we want to consider is going to be the timeline of doing a closing date. So again, we could list this property prior to receiving that certificate of probate. But one thing we do want to consider here, especially in a military community, is a lot of times those buyers need a definitive timeline of the closing, and we can't give that to somebody if we don't have this certificate, right? So I would definitely say if you're going to be selling your home in the spring and we're waiting on, or the assets are in the spring and we're waiting on this probate certificate, wait until we actually have this certificate, or wait until we have a 100% confirmation from Brent here that we know when we can honor a specific closing date, because that military member who's posted here to Petawawa or Pembroke area, they need a definitive closing date, and we can't give that to people if we don't have that certificate kind of in hand.
No, that's absolutely right. Yeah. It'd be something that you would want to expressly state to the purchaser's realtor, so they're aware that probate isn't received yet, and that it's identified probably in the agreement of purchase and sale. So if any extension is required for lack of receipt of that probate certificate, that the purchaser is already aware of it.
Yeah. So being honest and upfront, and again, avoiding that situation, which we've seen in real estate. We have a sale, we have a firm legal binding agreement of purchase and sale. And, all of a sudden later on after that firm date, it's discovered that we don't have an exact date on when we're going to get that certificate of probate. So definitely something we want to pay very close attention to. Yeah.